their clients would take advantage of the center to ensure that their matters are resolved speedily and harmoniously without the attendant friction of litigation. One area where we have also attempted to make a difference is in the aspect of the welfare of judicial officers, both serving and retired. A judicial officer's work is not from 9 a.m. to 5 p.m. The reality of our existence is that a judge's job is a 24-hour job. He sits in the court from 9 a.m. to about 3 p.m., if not later. When others close for the day, a judicial officer resumes his afternoon shift. That is when he begins to prepare his judgments and rulings. When others are resting at home after dinner, he commences his night shift by reading his files for the next day. There is no judge worth his salt that would not read his files before getting to the court. For the past 32 years, I have always had one judgment or ruling pending for me to write. I cannot recall a single time in the last 3 decades when there was no judgment for me to write. I am glad to see my younger brother Olukayode Ariwoola seated here now with us this morning. He has been based in the United States since his undergraduate days in the early 80s. Anytime I had traveled to visit him for vacation, his wife would always exclaim that she had never seen someone coming on vacation with records of appeals and briefs of argument for writing judgment. It is for this reason that I believe that emoluments of judicial officers must not be sweated for in or outside the office. Our judges must not be made to go cap in hand to beg before their remunerations is paid. Our retired justices deserve to live in a relative reasonable comfort after spending their prime years serving the country. This is more so that they are constitutionally precluded from going back to active practice as barristers after leaving office. If truth must be told, the welfare of the judiciary is the welfare of the country. I am glad that we have made appreciable progress in this regard with the passage of the bill for an act to prescribe the salaries, allowances, and fringe benefits of judicial officers, office holders in Nigeria, and for related matters by the National Assembly. It is also for this reason that we have instituted the Judicial Assistance Scheme for our justices in the Supreme Court. One peculiar feature of the work of a judicial officer is that his performance is not delegable. It is not an assignment that can be done by proxy. The brother judge cannot prepare your judgment for you. He cannot conduct your trial for you. He cannot assess your witnesses for you. It is thus a back-breaking profession. We thus instituted the idea of judicial assistance to provide relief for justices in the area of research and documentation. This crop of staff will aid the work of their lordships by conducting research for them. It is hoped that the scheme will be a permanent feature of our justice system at all levels. When I became the Chief Justice of Nigeria, I was concerned about the fact that the rules regulating procedures in the Apex Court were those made 39 years ago. Although practice directions have been issued at regular intervals over the years to meet demands of justice, the substantive rules were still as made in 1985. I am convinced that the rules of procedure of any court are the engine that drives its operation. It is also my view that the rules must be dynamic and contemporary in order to meet the changing demands of both the bench and the bar. At the time the Supreme Court rules 1985 were made, things that are now ubiquitous, like information technology, electronic transactions, and global telecommunications, among others, were either not in existence or in their formative infancy. How then could such obsolete rules be adequate for the challenges of today? It was for this reason that I empaneled the Rules Committee to undertake the arduous assignment of reviewing the 39-year-old rules and the many extant practice directions comprehensively. I'm glad to report to you all that earlier this month, pursuant to the provisions of Section 236 of the Constitution of the Federal Republic of Nigeria, 1999, I signed off on the new Supreme Court Rules 2024. In this regard, I must not fail to commend the wonderful job done by His Lordship's the Honorable Justice Kudirat Kekere-Efen, JSC, Justice Iyan Gokoro, JSC, Justice Marom Keji Eni Nogumeji, JSC, Justice Tigane Abubakar, JSC, Dr. Muiz Banire, SAN, and the Makayao Yakubu, SAN. Their dedication and commitment ensured that the new rules became a reality. I'm indeed very grateful to them. There is this executive summary of the new rules. The Supreme Court Rules 2024 has repealed the Supreme Court Rules of 1985 and has crystallized all the existing relevant rules and practice directions into one body of rules for easy access by the court and legal practitioners who practice in this court. The Rules Committee, which, as I said, was chaired by Honorable Justice Kudirat Motomori Olatokunbo Kekere-Efen. Other members, as I said, are Joniyan Gokoro, JSC, Ogunwumeju, JSC, Tijana Abubakar, JSC, and the immediate first president, who is also outgoing like me, Honorable Makayao, and Dr. Muiz Banire. The Rules Committee's secretariat comprised of Ibrahim Gold, Esquire, Yusuf Babasturo, Esquire, Saadatu Ahmed, Esquire, Zainab Garuba, Mohammed, Esquire, and Patricia Ovomulu, Esquire. These all are well appreciated for their dedication and commitment to the work. The new Supreme Court rules have the following highlights, if you care. Extension of the hours when the registry will be open and the formal introduction of a comprehensive e-filing system, the introduction of the service of most processes by electronic means, the virtual hearing protocols have also been set out in detail. The electronic case settling and management system will be put in place. In the near future, a Nigerian Case Management System, NCMS, e-filing portal would be available to counsel and the court. More duties have been imposed on the bar to aid the speedy hearing of appeals, where service is effected on a legal practitioner who has ceased to appear for any party. Failure to inform the court expeditiously will be deemed an act of professional misconduct. Service on the Attorney General of the Federation or an Attorney General of a state is deemed sufficient service where the federal or state government of Nigeria is a party. Parties are now mandated to file notice of non-contention when they do not intend to contest an application. Most applications for leave shall be heard in chambers pursuant to Section 233, subsection 3 of the 99 Constitution as amended. One of the most important innovations in these rules is the execution of the policy to reduce the volume of applications for extension of time which have been abused over the years. Now, time provided by the rules is automatically extended for the same period in the first instance. It is also further extended for same period provided with the payment of penalty in default, and no application for extension of time shall be entertained thereafter except in an appeal against a third penalty. This simply means that if you have 7 days to file a process, if you do not do so, you have another 7 days automatically so to do the needful. After the cumulative 14 days, you have another 7 days, in which case you will pay penalty for default. within that third 7 days. After 21 days, there is more extension of time. Importantly, no application will be entertained by this court. The time to file briefs have been reduced. A section of the registry has been created to manage the electronic processes, including the electronic copies of the record of appeal. It is now mandatory for the appellant in this court to pay costs awarded by the court below into an escrow account. To ensure diligence in appeals against monetary judgments, the court will require a guarantee or bond from a reliable and reputable financial institution as a condition to hear the appeal. Where the appeal relates to land, an undertaking to pay damages where the appeal fails. This court will not grant stay of proceedings in an interlocutory appeal brought before it. Where the appeal fails to comply with the conditions of appeal, this court is so motive dismiss the appeal. With regards to costs, the court will now adequately award costs to compensate the respondent for the time and expense in coming to court. AFC. Where counsel engages in an abuse of the process of the Supreme Court, punitive cost will be awarded personally against such counsel, including a counsel representing the federal or state government on an institution or representing an institution. Counsel who fails to pay costs awarded personally shall not have right of audience in any superior court of Nigeria. There are provisions made to fast-track criminal appeals relating to terrorism, rape, kidnapping, money laundering, corruption, and human trafficking. The procedure in election matters have been elevated and incorporated into the rules with enhanced guidelines to ensure speedy dispensation of justice. Learned senior advocates may appear with not more than 5 learned friends. Where more than one senior advocate appears in a matter, the total number of counsel shall not be more than 8 for the party. That is the executive summary of the 2024 rule that you will soon have on your hand. As a young star, I was an avid reader.
GCFR is very much aware and conscious of the present hardship in our country and the hard times that all the citizens of the country are presently undergoing, like what happens in most parts of the world. The government appreciates the resilience of all Nigerians and appeals to our people to kindly bear with it and be assured that the ongoing hardships are very temporary and will soon give way to an era of prosperity and rich growth and development in Nigeria. The government has put several measures and economic policies in place that will soon mature and transform our country into one of the top economies in the globe. For my Lord Honorable Justice Olukayode Ariwoola, today marks the end of a most memorable and impactful judicial career, which spanned a period of 32 years, from when he was first appointed as an High Court judge in Oyo State in November 1992. Indeed, his lordship came, saw, and conquered. He has made his mark and left indelible imprints in the annals of the Nigerian judiciary and the legal profession in general. I must remark that the outgoing Chief Justice of Nigeria is a stabilizing factor who mounted the saddle at a challenging moment for the apex court, and he has creditably sustained the sanctity of this hallowed court, both as a court of policy, final arbiter, and regulator of the justice sector. As his lordship takes a well-deserved bow today, permit me to specifically appreciate him for providing leadership, guidance, and his firm commitment to improving the well-being of the judiciary, to which he has contributed immensely. This has culminated in the harmonization of retirement age of 70 years for judicial officers, attainment of a full complement of 21 justices for the Supreme Court, the enactment of judicial office holders, salaries, and Allowances (ETC) Act 2024, which was recently assented to by President Bola Ahmed Tinubu. The foregoing signposts the commitment of the present administration to promoting the independence and capacity of the judiciary and advancing judicial reform. The government is also working on other reforms in terms of policies and constitutional amendment to increase access to justice, transparent appointment process, ensure speedy administration of adjudication of cases, increase public confidence in the judiciary, insulate judiciary from undue interference, and so on.